Now I'll call to order. A roll call, please.
Vice President Cons,
Here.
Director Wilburn,
Here.
Director Yanez,
Here.
Director Payne,
Here.
President Shandy.
Here. The Pledge of Allegiance will be led by Director Yanez.
Is this on? Oh, good. There we are. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mrs. Ruckman, are there any updates to the agenda?
No, there are no updates to the agenda.
Are there any discussion items to be added to the agenda? May we have a motion to approve the agenda?
Moved.
Second.
Roll call, please.
Vice President Cons,
Aye.
Director Wilburn,
Aye.
Director Yanez,
Aye.
Director Payne,
Aye.
President Shandy.
Aye. All right. Item up for board consideration is whether to take action on joining the litigation titled School District 49 versus Sullivan and all number 25-CV-1463D Colorado, following discussion on its potential implications for our district in alignment with board values and legal responsibilities. Let me take a moment to just say, always in my own attempt to always be better, self-analysis, I think I let our meeting last time get a little too informal, and so I will be tightening that ship tonight a little bit, just so you know. And then also to keep it tight, I want to make sure that we're clear on the questions we have that we want to have answered. I walked away with the question amongst everyone was we weren't clear on the cost of it. If there are other questions, please raise them now so I can notate them and make sure we answer them.
President Shandy?
Yes, ma'am.
Okay. I'd like clarification on, we've had some discussion about if joining this lawsuit, it would offer protection for the district if other lawsuits were filed against us regarding our resolution or policy, upcoming policy. So I'd like to get real clear on what is protected, what's not protected. Are we just deferring if we join the lawsuit? Is that just deferring?
Stay.
Yeah,
Okay.
other suits that might come up. You talked about the cost. I'd like to discuss what fund or funds this would come from. And I have one iffy. I'm not going to state it at this time. It could be.
Okay.
It's kind of a moot point right now. So thank you.
Director Yanez.
President Shandy, I was gonna also add, I think one of the questions we walked away with was the timeline. So when is too late to join or not?
1 second. Superintendent Haber.
So I appreciate this opportunity to explore cost a little bit more and to list all the questions right now. I would like to ask for the opportunity for Deputy Becky Allen, CFO, to follow up on the similar question as far as where would the money come from. But what our normal process is in D20 when we have a potential contract in front of us that would be potentially go over a certain limit, no matter what that contract is we really dig into it and we ask a series of questions about that. So I would like to ask that Deputy Becky Allen, CFO, would have a chance to ask her questions. And then I also looked at the sample agreement that we were given, and I have some specific questions, but they're all very much so, I think, connected to cost, which is, those were the two topics, right? Timeline and cost. And so our Deputy Allen, but to list them all, that would probably it'd probably just be quicker if Becky could have Miss Allen would have a chance to ask her questions, and me as well, just because we are in the weeds, right? When if this were to go forward and just have questions to ask about.
Okay. Okay. All right, I would like to at this time ask Mr. Ellis and Mr. Murray to please come to the table. These are attorneys that are representing the lawsuit and are here to answer our questions. Thank you, gentlemen, both for taking your time to be here. Appreciate that.
Thank you, President Shandy, and as my colleague, Mr. Ellis, noted to a couple of you before the meeting, we usually like to be the ones asking the question, so this should be fun.
It's always good to be a little uncomfortable in life, right? All right, so you've heard most of our questions right now. So I'm going to give you an opportunity to address the big question of cost, and then we'll just kind of roll from there.
Sure, and maybe I'll begin. There may be some times where I defer to Mr. Ellis, but that way there's just one of us speaking. So first, cost. There are, so the overall cost of this litigation that we are estimating, and this is through a trial, so an actual trial to the federal district court here in Colorado, is $1.5 million. We think the likely cost to Academy District 20 as a large participant under the draft engagement letter, which I know we're going to get to in a moment. I had it's going to be probably under $300,000, under 20%, and actually closer to about $250,000 or $240,000, because candidly, we continue to get increased interest in participation in the litigation. That's through trial. I'll say that the immediate near-term cost is on the order of probably $60,000 total, with about 15% of that, looking like about $10,000. That's through a resolution on a motion to dismiss. We anticipate a motion to dismiss from the defendants. There should be a motion to dismiss from the defendants because initially there is a really big legal issue here, right? Which is, what is the conflict of laws between what is the conflict between Title IX and the Colorado Civil Rights Act? Is there any conflict within the Colorado Civil Rights Act? And is there any conflict between CHASA's transgender participation policy and Title IX? And we would expect that the district court will want to pass on those legal questions before potentially letting the case proceed forward to a trial.
And so when you say immediate, the 60,000, when would that be due?
Over the next 3 months.
Thank you. Superintendent Haber.
So in the draft agreement that we got, and I'm making the assumption that the agreement that we would be looking at, we could be similar, but I know this was written by somebody different.
Yeah, that was written by our partner, Michael Francisco, who is actually on a graduation trip with his daughter right now.
Yeah.
So
down on the bottom where it talked about pro rata division of fees, I guess a question I have is, right now, I know you have lots of prospective people who want to join. My understanding is that right now you've gotten written signed agreements from only 2 districts, which is D11 and D49. Is that correct?
In the large district category, that's right. What about?
I think there's a distinction between signed agreements in the door, and I don't think we even have D11 that's signed.
Right.
Everyone's going through the process right now of getting this approved, just like you are. Our anticipation is we will have 4 schools at least in that large category that we've been talking about.
Can you say who the 4th one would be? Because it's on here too, but when we ask, I don't know who the 4th would be.
Not yet. Perhaps in executive session, we could provide what the client group would be, but they're still going through their internal process, and I don't want to shortchange that process. And then there's another 4 smaller school districts. So we anticipate at least 8 school districts, 4 being much larger than the other 4. And that's how we get to the percentages that we've arrived at. And so we kind of look at this. If we're only talking about 8, 4 large districts, 4 small districts. It's broken out into basically shares. So just 12 shares. So you would be 1/6 or 2/12 of the cost. In a smaller district will cover 1/12 of the cost. So it would be roughly 16.67%.
Would it be possible to know, so if the board were to vote today to say we want to join the lawsuit, then my assumption would be that what we're saying is we're willing to engage in negotiations around that. Certainly from our perspective, not knowing for sure that anyone's really signed an agreement yet, except for D49, it just kind of feels a little that I know I personally would like to know for sure. Those numbers that you gave are certainly better than what we are considering, but we don't know for sure that those are going through. And I know for the timeline, you told us that to join it was, June 24th. Is that the same timeline they have? And then my second question along the timeline, because I think it's related to this too, is my understanding is that if we didn't join by June 24th, we'd still have the opportunity to join toward the end of July through an addendum process. So those are 2 questions.
Yeah, so on the timing, the amendment process, which is governed by Federal Rule 15 of the Federal Rules of Civil Procedure, we get one chance to amend the complaint as of right. And we are in coordination with the defendants out of courtesy in the litigation process to notify them, because certainly we don't want them doing unnecessary work, perhaps working on a motion to dismiss, if the target, the complaint, is going to be moving. So, our internal goal is to give them enough time to their current deadline to respond, I believe is July 16th. We work backwards 14 days from that day. And that's how we get to the end of June 24th, where we're looking for a final resolution on the numbers, because to your point, you're making an informed decision about who is in the group and what the cost is going to be. And so we have asked everyone to give us a hard yes or no by that time, so that you have a better sense of what the commitment is financially to the district. But I want to stress a point too, and that's on timing. Another point on cost, we are giving you kind of the worst case scenario. There are lots of different off-ramps that could minimize cost in various ways. And, I can go into some of those different ways without going into the litigation strategy, which I cannot do. And so there are levers to pull that will minimize cost in different aspects of the case. And so when, we're talking about $250,000 total through trial for a 16.67% share, it is much likely that number is probably going to be much lower, perhaps in the $150,000 to $200,000 range. Again, it depends on how the federal court decides to approach the litigation, the scope of the discovery, the experts engaged. That is often informed how the defendants here, the state, and CHASA decides to defend the case. And so just, Superintendent, I want you to keep in mind the number that we're giving you is kind of that outer band of what we anticipate, just because we don't want the school district to be surprised with any numbers.
And just one other thing I'll add to that too on the timing piece. The reason why we work backwards from the July 16th deadline that they have right now to respond as to when we amend, I could see the question on your face, Superintendent. Why would you do that? Well, because once we amend, Federal Rule 15 gives them 14 days to respond. It basically changes the clock, right? And so this is this is an important case, right? And the defendants on the other side have to wrestle with the same difficult issues that we on this side have to wrestle with. And frankly, the process isn't served well if we start out by playing procedural games with each other. And so we've reached out in good faith to those lawyers and said, hey, something like this might be coming. And, you know, we understand that they would not want us to play a game where we try and shorten the amount of time they have when they've just invested a bunch of the time they already had under the rules in getting ready for the complaint that we filed when we're going to change it. So we don't want to start by sandbagging them.
So joining later then from what I heard would feel like sandbagging. Is that what you're saying?
No, so I didn't address your second part of your question in my original answer, so thanks for bringing that back up. So for us to amend the complaint later, right, to add additional parties would require leave of court, and you're going to have to get a federal court to approve that. I'm not saying it can't happen. It's much less likely to be able to happen, particularly once the defendants have filed a motion to dismiss and we are litigating a motion to dismiss at that point in time. So it's kind of, you know, based on the procedural posture of the case, and it's why Federal Rule 15 is structured the way it is. You get one chance up front, then once parties start to litigate the case and make their strategy known, and they start moving the chess pieces, then it gets harder to amend the complaint. Not impossible, but harder, and you have to have court approval.
Yeah, go ahead, Superintendent.
So another question I had in the financial terms in this was it said that in January 1st of each year, you normally adjust your rates, and then it says, you know, you agree your obligation to pay that. Do you have an anticipation of what your rate increase would be?
So I have the benefit of being the co-managing partner of the firm, as well as a firm partner, which comes with all the additional administrative responsibility and no additional compensation. I will say that to my partners in live meeting.
Thank you, Julian.
This past year, we did not increase the rates. Historically, it's never been more than 5%.
I just actually have two more related to this. And so in looking, the fees, you know, were $600 an hour for Chris and then Julian at $560 an hour. And then on the back, there was out-of-pocket expenses and public relations expenses. I'm assuming when we said that we were pro ratus that you would roll all of that together. And that's what you were giving us in your estimate that you just gave, or was that just for attorney's fees?
No, that's exactly, that's all in. So that includes experts are going to be a big part of this case, and understandably, public relations are going to be a big part of this case because it's a public-facing case. Public law is a lot of what our law firm does, and so sometimes you have really an obligation to communicate with the public about the case while it's going on. That's not to litigate it in public, but that's simply the public deserves to know what's going on in this case, and not everybody knows how to access and read court filings.
So that estimate would include those other pieces
Yes.
as well. And then I think for now, my last question is in CHASA's bylaws 810.10, it says that the members of CHASA, if they choose to bring about a lawsuit against CHASA, that we would also be, because we are a member of CHASA, that we would also be responsible for paying their attorney fees. And so when we're looking at pro ratus, I guess knowing that, and I assume that 49, probably 11, most districts are members of CHASA. I would assume the two other larger districts are. We'd be paying for your firm's attorney fees as well as under the bylaws, their attorney's fees as well. So we just kind of recently learned to be like, we're paying them for the lawsuit when we're suing them. And so I'm wondering with the pro ratus, does that piece enter in at all for what we would pay you or in our agreements with the other districts, or is that something that would be separate?
So it's separate, and we've been in contact and communication with opposing counsel, counsel for CHASA. There hasn't been a reservation or a invocation of rights under that clause that we've heard so far. I'm not aware of its use, not to say that it can't be used, and you should certainly coordinate with your general counsel, your in-house counsel here on what your obligations may be under that agreement. I will say too that while we're talking about fee shifting and indemnity, there's also we brought this as a civil rights case under the in part Section 1983 of the United States Code, which provides for the recovery one way for plaintiffs of their attorney's fees if they prevail. So there's also the option or the opportunity to recover your fees, our fees as a collective, as the plaintiffs, from the defendants if we were to prevail.
Anything with CHASA would be, what you're saying is the agreement with CHASA that says that we actually talked to the head of CHASA this morning about that. And from our conversation, I got the sense that they would move forward with that. So it's interesting to hear that they haven't said anything about that, which could be a good thing. But would that be something then, what I'm hearing you say is that agreement with CHASA and their bylaws saying that we would have to pay their attorney fees as well would be something really separate from the agreement that we would have with you and the payments we would have with you?
I think it would be separate in terms of its legal enforceability and separate in terms of your obligations under it.
All right, thank you. Director Cons, does that answer your question on timeline? I'm sorry. No. Oh, and Director Yanez, does that answer your question on timeline?
It does, thank you.
Thank you. All right. I believe that answers the question on cost as well, $250,000 over 2 years. Superintendent Haberer.
If I could please give Deputy CFO Becky Allen a chance to ask her questions too.
Nice to see you. Thank you for coming and helping with the questions.
Of course, Ms. Allen.
As you mentioned earlier about budgeting, we do the same. We're funded dead last in the state. Hard to believe in Academy District 21 that's so successful and one that is booming. But we have the lowest funding in the state. And one of the strategies that we use with our budgeting is to do so very conservatively. Sir, as you mentioned we like to plan for what the worst could be. I don't use the worst, I just say the biggest budget impact, which is why I ask some of these questions. The other challenge that we have obviously is also knowing when might that expense occur. So if it's okay, I'd love to go back. I've learned that there's potentially, and please correct me if I'm wrong, I am certainly not an attorney, but there could kind of be 3 levels, kind of the state level, the 10th Circuit level, and potentially Supreme Court. Now, I know that's way off in the distance, but as the person responsible for the finances, my question to you is, would you please be so kind as to give an estimate of the total amount? Let's just start with total. That might be an easier place to go. Then we could apply the 16.67% to have an idea of what our share would be. But if we could go state first, what might that total cost be? And when would be expected to actually pay the 16.67? And then if you don't mind, I'm going to ask the same question for the next 2 levels to give us dollar and timing.
Sure. Well, so I'll say first, the leaving aside this the share percentage, right? The number that I
Yes.
quoted earlier, $1.5 million is the state. That's actually the federal district of Colorado. That's the same thing. It covers the state of Colorado, it's just
Perfect.
federal court.
Thank you.
The timing on that, as I said, there will be an initial spend in the range of for everybody, probably about $60,000.
And that's the total again. We're just going to
That's the
do
total. That's the
Okay.
total, correct. In the motion to dismiss phase, that will be in the next 3 months. There is an additional, maybe say 20,000 to 30,000 spend that might come on top of that. If it goes up to the 10th Circuit on the motion to dismiss, right? That's just the question of, hey, legally, can we even be here? That would be probably within the next 8 months or so.
So the motion can go up the levels before really the case has.
It could,
Okay.
only if we lose,
Gotcha.
right? If we win on a motion to dismiss, the other side can't ask the 10th Circuit to review that. The case goes forward. And that's just the way the rules of procedure work. Then the rest of that cost, which is obviously the lion's share,
Yes.
you would probably have, Julian, feel free to chime in, but I think you're going to be spending, about, around $900,000. Again, this is across the group, over the next year after the motion to dismiss is decided, and that is in what is called the discovery phase. It's also known as the incredibly boring phase of litigation. It's the phase where everybody forgets the case is there, right? Because what you're doing is gathering evidence, providing evidence to the other side that they have asked you for, finding expert witnesses, deposing the expert witnesses of the other side, all that sort of stuff. It's basically the long slog to trial.
And you think it would likely be in, our fiscal year is July 1 through June 30.
Mhm.
So let's just say 25, 26. Do you think that chunk would hit that year?
A piece of it, yes, especially if we prevail on the motion to dismiss.
Sure, then it would advance it a little faster to the discovery phase.
Correct. If
Okay.
we take a trip up to the 10th Circuit on the motion to dismiss, then
Sure,
very little of it will hit in
Okay.
25, 26.
that helps.
And then the last piece, which, I would estimate across the group to be between $400,000 and $600,000, right, is the final sprint to trial and trial, right? So final trial preparation and the conduct of a trial. That is, in terms of compressed amount of money, that is the most expensive period of time because it is very lawyer intensive, and it's also intensive on expert preparation. And, if you've got a 5-day trial in federal district court, you'll probably have 2 or 3 lawyers there representing you. That time adds up when you're
Sure.
talking about 10 or 15-hour days for each one of them.
Yes, sir. And sir, are you guessing then a trial at the state level would likely bear a cost in 26, 27? Is that probably the most likely
Yeah, I think
ballpark?
likely Q2, Q3 of,
26, 27?
26,
Okay.
27.
Thank you.
But that is really a guess at this point. It's definitely
It
not,
gives
it's
a
definitely
ballpark.
not in 25, 26. We can
And
tell you
that's
that.
what helps, as you can
Mm,
imagine.
yeah.
Obviously, you said earlier, we don't like surprises. I never want to come to our Board of Education and say, boy, I really miscalculated here. We like to be very conservative, as I said, and make sure we're set up. May I please ask you, could we go to the next level and
Yes.
plot that out? So it goes to the 10th Circuit.
So that would be likely at the earliest, because this trial would be to the court, right? It would not be to a jury, which means that the federal district judge who hears the case, right now that's Senior Judge John L. Kane, would have to issue a written opinion. And I would imagine that the judge will take his time writing that opinion because of the importance of this and frankly, the complexity of the issues in the case. And so I would guess that, and who knows, maybe he'll listen to this and quote it to me in a while, but I would guess it'd take him at least 2 to 3 months after a trial to issue a reasoned opinion. And then and only then does one side, whoever's losing, have the chance to go up on appeal. So I think you're talking about fiscal year 27, 28. And in that year, you're almost certain to be at the 10th Circuit in that year. And Julian, what would you estimate the appeal on this to be at the 10th Circuit level?
You know, it really depends on whether we've won or we've lost.
Let's take the worst case scenario.
And so if we've lost, we have 2 briefs and an argument. And so you're talking about in the $250,000 range total for the collective.
So not as expensive at the 10th Circuit.
No,
No.
because it's just briefing an argument at that point.
I
The most
understand.
yeah, the
It's
mo-
not a litigated trial.
Right. The most expensive part of this is the factual development and getting ready for trial.
Got it. And so the 10th Circuit would be about 250,000, probably in 27, 28. And then if, again, it went to the next level, we're probably looking 28, 29, I don't know, but what might those costs get to?
Again, it depends on whether you've lost or won at the 10th Circuit. Let's assume you've lost, and we are filing the petition for writ of certiorari to the U.S. Supreme Court, which is a discretionary review device to the Supreme Court. You know, you're talking about maybe $45,000 to $65,000 for the petition. Again, collective cost, and then if the court were to grant review in the merits phase of the case, it would be similar to what you saw in the 10th Circuit, around $250,000.
And if it had to be, there was an attorney presenting to the Supreme Court?
The $250,000.
Oh, okay.
Because there's more judges up there, but it's this, or justices, but it's
Sure.
the same procedure. It's just an oral argument.
And gentlemen, if, when you share these numbers, just so that I have clarity, this would, except for what CHASA issues may arise in terms of legal bills that we're not sure if we would be responsible for at the time, this would include the paper clips, the copies, all of the supplies that we talked about, but also, would it also include then, just to make sure, there would not be a separate bill from the public relations firm? This would be embedded in this.
That is correct. Hold on, Julian, are we using the gold paper clips for this one? No, yes.
Because you had a section
No,
on
it's,
supplies,
it's,
so.
it's absolutely a fair question. Yes, we're giving you the number, including all of that stuff. So basically, those numbers that we're giving you are not all the legal fees.
Okay.
Or they include all the legal fees, but they're not all legal fees.
And then, gentlemen, I don't know, that was very helpful, and for the timeline, thank you. I don't know if this is something that you'd be willing to share, or to estimate, because I'm asking for an estimate, really. If, again, because it's my job to budget from a position that we are going to have to pay these potential pieces to prepare for that. If the CHASA legal fees were our responsibility, again, at some type of pro rata share is my guess, is there any estimate that we could have on what that could possibly be? I would not hold you to it, but you're experts in your field. I am certainly not. So I just don't know what to even guess what something like that could be.
And then I'll speak frankly, the reason it's very difficult to estimate them is because we haven't yet seen who's going to take the lead in defending this case, right? There's multiple defendants on the other side. My working guess would be CHASA is going to do some looking to the state and saying, you guys kind of help get us here. Maybe you want to help get us out of this, right? And may lean on the state's resources to defend the case, which would significantly lower their legal fees. So I don't think their fees would be in the same ballpark as ours, as plaintiffs who have to carry the case entirely against these defendants. But could they be half or 2/3? I think they could. Could they be significantly less than that? I think they also could. And I would bet you we'll have a way better idea after the motion to dismiss phase, when we see how the defendants decide to allocate resources between themselves.
But a reasonable assumption on the part of trying to, again, prepare for that rainy day, right? To make sure that we're ready would be maybe 2/3 of all of the costs that you just shared, a pro rata share of that.
I think that would be a good working worst case scenario for now.
Thank you.
Yep.
I appreciate that. Thank you. May I ask one more, or is it not
You
okay?
get one more.
One more. Okay. And again, this shows my ignorance around this.
All your questions have been excellent so far.
are the fees that we would pay or even that CHASA would pay, are they contingent at all on the outcome? In other words, if you win versus you don't, are there any changes in the fees associated with that?
And I'm betting Mr. Ellis will have something to add here, okay? But the short answer is yes. At the bare minimum, for example, if we win on a motion to dismiss, there's no first appeal up to the 10th Circuit. Those fees go away. If we are the winner at the trial, the appellate costs go lower because the person who won at trial only gets one brief, right? So there's just less to do. Even if you want to have another brief, which sometimes you do, you don't get it. Same thing at the Supreme Court level. If we've won at the 10th Circuit, we don't have to respond to a petition for certiorari. Most people,
The burden of proof shifts to the other
well,
person
it's-
with the appeal?
it's their burden to get the court to take it. And so most of the time, given how few cases the Supreme Court takes, you know what the person who won does? Yeah, I'm okay, thanks. You guys just go ahead and decide that, right? So that is one way that they're contingent. Another way that they are contingent is, I haven't studied 810.10, so I'm not going to comment on what happens if you're a prevailing party in a lawsuit against CHASA. It could be a one-way ratchet for CHASA, I don't know. But if you prevail on this case as a 1983 plaintiff, you will be owed at least a portion of your legal fees because federal statute requires that they be awarded to you. So does it lessen the fees? No. However, if you're budgeting, right, is there a possibility, right? Is there, you know, a contingent interest potentially in a fee recovery there? Yes. And when would you get them? Probably after the fiscal year where you've incurred them,
Sure.
right? So at some point they might show up and you'd say, oh, well, that's a nice surprise. But Ms. Allen, I take that most of your questions are not asking about nice surprises.
Only if they're good ones, right? Mine are more, you know, just again, that path. And now, sir, I understand why you were kind of giving me, it depends if it's a win or a loss along the road. And it sounds like the numbers you gave me showed more of a case of a loss, if you will, just to look at the deeper amount of money that might be needed. Thank
Yeah.
you so much. I appreciate you taking my questions.
Thank you.
Thank you, Ms. Allen. Those were excellent questions. Thank you. All right, so I believe that that answers the question on costs. Next question that we have is clarification on protection of other lawsuits. Can you please clarify
Sure.
on that question? And if you need more
No,
understanding, Director Cons.
no, President Shandy, and I'll say what I take the question to be asking. And if I'm getting started on asking a question that you don't want answered, just let me know and then we'll get the right one.
Will do.
But I take the question to be asking, look, this is a fraught issue, right? It is always possible that somebody, again, in good conscience, could disagree with what this board decides to do in adopting a policy of this nature and in joining this lawsuit, and might say, you know what, I'm going to try and drag the district into court at a place of my choosing, right? And does joining this lawsuit, or I'm going to file a complaint with the Colorado Civil Rights Commission, does participating in this lawsuit protect against at least the costs associated initially, right, with that sort of an action? And the protection that we believe it provides is a very practical one that is grounded in the judicial and administrative doctrines of abstention, right? So if you're in a federal court litigating the very issue, which is, can we adopt this policy? Is this policy necessary under Title IX? Which way does is transgender participation in sports actually discrimination against women, or is it the other way around to not permit that participation? Is that the discrimination? If you are actively litigating those issues in front of a federal judge who has statewide jurisdiction, in my experience, if somebody files a lawsuit after you're in a case like that, a state court judge or another federal court judge or a hearing officer at the Civil Rights Commission is going to say, all right, got the complaint? I'm not dismissing the complaint. The person has every right to file it. but I'm going to wait because there's no point in lawyers spending a bunch of money litigating this very same issue that the school district has already decided and volunteered to litigate in another forum. I'm not going to make the plaintiff or the complainant in that case spend money. I'm not going to make the district fight it in more than one place because there's a legal question I need resolved here, and we might as well get it resolved before we get started because it might change our proceedings. It is that sort of a practical protection. Does it foreclose anybody from bringing some kind of a legal action or a complaint? It absolutely does not. And by the way, it shouldn't, right? That you can't close the doors of a court to somebody, but does it practically mean that whoever the judicial or administrative officer it is that is faced with that, I'll call it subsidiary claim, that is it much more likely that they're going to say, I'm going to let this bigger process play out? Yes, in my experience as an attorney. I don't know if you want to add to that.
Sure. Thanks, Mr. Oh, go ahead. Do you have more, Julian?
So there is both, like, there is a legal impediment under, it's the supremacy clause that actually says that the federal courts and ongoing proceedings are supreme or superior to any ongoing or subsequently filed state court action or administrative action, say, in the state proceedings. And so the question really becomes one of fit and relatedness. So how closely are the issues in the state proceeding, again, whether in court or in an administrative proceeding, are to the federal proceedings? The closer that fit and the relatedness, the more likely, both legally and practically, the state court proceedings are going to defer to the federal court proceedings. The secondary consideration is who the parties are. We have sued the Civil Rights Commission, so it makes that fit much closer. Say if you were to have a proceeding by a student or an interested party against the school district before the commission. And so, it really depends on who it is, but in our experience, what we have seen is that if the issue is being actively litigated in federal court, the parties are going to defer to that process because at the end of the day, the commission, the state, CHSA, and the districts, the reason why we have this lawsuit is for certainty and clarity around this issue. And I think they're kind of rowing in the same direction on that as well.
So just thank you both for your answers. Just to oversimplify, say we joined the lawsuit. Two situations, and complaints were filed against us, similar complaints, and we lost this lawsuit. Then would those complaints be addressed again and proceed forward? That's one option.
And that's a real, I hate to say this, so yeah. I'll go on the other side of it, but it depends.
Mm-hmm.
So here's what it depends on, right? There's a way that this lawsuit could be lost where, okay, we're wrong about the law, period, right? The federal courts have decided otherwise, and in fact, the law requires the opposite, right, of the policy that underlies the basis for this litigation. In my experience with the Civil Rights Commission, most of the time what people are seeking there is somebody to change their behavior, right? To better accommodate a party who requires accommodation under the Civil Rights Act. Well, I don't want to speak for a future board of directors, but I would imagine that if you lost this lawsuit, you might reconsider the policy and say that we don't really have we don't have legal grounds for the policy. It's incompatible with superior law. So even if we might like a different policy, we can't do it. Well, if the relief that somebody is seeking is relief that is possible after the rescission of the policy, it might make that case go away really quickly. Mm-hmm. On the other way, if you win, well, you didn't ask if you win. You know what happens if you win, right? It might also be, though, that there's another case where if it's a case for money damages, right, that, you robbed me of my opportunity to participate in a sport that I wanted to for the 3 years that I was in high school. That case, if you lose, could very well still go forward. I mean, I'm speculating about
No.
what the nature of a lawsuit would be. It really would depend on the plaintiff and the facts and all that. But there's some that I could see would practically move forward. There's some that I could see would almost certainly not.
Sure, and I understand. So the other situation, and this is the clarification I feel like I need before we vote on this. Is it accurate to say if we did not join this lawsuit with D49, and we had complaints filed against us, against our policy, our upcoming policy, those would proceed through the court because we're not under the lawsuit at all?
Much more likely. Remember what Mr. Ellis said just a moment ago, that it becomes about fit between the proceedings. So if you have adopted a similar policy, okay, there's a piece that fits, right? That looks the same as what's in the federal court. But then all the other pieces of the fit aren't there, right? You're not a party to that case. In fact, look, this is one of the hard things about being a public body and making decisions, is that you have to make decisions like this in public, right? But you make that decision, you've actively made a decision to not do it, right? That is going, I guarantee, if I'm the plaintiff's lawyer, I know what I'm saying about that argument on fit. And I'm saying, they don't want to, they didn't want to be there, so we're going to make them go there, right? I'll say that, is there still a chance that a state decision maker might defer to that process? There's a chance. I think the chance is significantly lower because the fit is significantly diminished because you are not a party to that proceeding.
Thank you.
All right, do you feel good about that answer, Director? Okay, very good. So that leaves the last question for Superintendent Haber. The funds this would come from most likely?
Yes, I'm going to defer to CFO Deputy Becky Allen for that question.
So if I take a look at the notes that I took when I asked about the timing of the different payments, we know that our 25-26 budget has that's been adopted. And obviously that budget reflects our anticipated expenditures. This is not in there. So where the money, and I'm looking at 2020 or 25-26 next fiscal year, it was about $960,000 was perhaps a ballpark for 25-26. If I use my calculator and do 0.167 times. So next year, if the 4 small and 4 large, I think I had that correct, if they all come through. So please keep in mind, we would also be very closely watching. If that does not come through, then these dollar amounts would obviously grow based on the pro rata share. So that to me looks about like $160,000. So where that will come from is our unassigned fund balance. So our unassigned fund balance, that is exactly what it is. It's sitting there. You know that ours is projected at 8.67% next year. It sits currently for next year at 30 million. And so we would take it out of there. People always ask, so what does that mean you would not do? So that would all be trued up at the mid-year. So when we bring a mid-year budget to you in January, that is where we handle all unexpected things, and some not necessarily unexpected. We expect some true up with enrollment, right? I've always said, if I get the enrollment right in a school district with over 26,000 students, I should go then buy a Powerball ticket. We know it's either going to be higher or lower, highly unlikely that we hit it on the target, so we make an adjustment. We made a projection regarding our SES valuation that would most likely need some tweak to what the actual is. Our per pupil revenue from the state could change. We true that up. We true that up with other types of unanticipated things that happen. Some things come in less expensive, some more. So what would happen, we are going to have to, it sounds like, pay some money before the mid-year. So again, unassigned fund balance is where it would come from. But at the mid-year, we look at everything that's unspent this year. That moves to next year, right, as part of our unassigned fund balance. And we look at the true ups that we have to do. And when we look at, well, what ultimately would have if $160,000, or we might be discussing that we would want to put more money away for this lawsuit, anticipating the other years coming up to be prepared. Bottom line, that would come the last thing that we do after we true everything up. We look at our anticipated changes, all of those pieces. We come down to, after we look if there's a bonus for staff, we don't do that every year, we did last year. The bottom line, the remaining dollars, once we determine what that unassigned fund balance percentage is going to sit at. Remember, it can't go above 12%, and I would highly recommend we don't go any lower than about 8.5% where we are right now, or 8%. Then those dollars get moved to the capital reserve fund. So at that point, if we had to expend something unanticipated, that would have been shrunk a little bit. And then and the bit is however much we had to pay. So if things come out the way they said, the gentleman shared, almost $1 million next year, pro rata share puts us, as I said, in 160, 170. So then that perhaps is 160,000 less in projects that we would be able to do that year. I can certainly give you a sampling of the projects that are typical types of projects each year, if you would like that. But that's really how that works. If that amount became much larger for some reason, less folks joined the lawsuit, what have you, then that becomes less money than that goes to the cap reserve
So
fund.
Ms. Allen, you don't have those projects already allocated,
Yeah, yes, we have them. I can let you know what we are planning.
but I'm saying, why would they come out of the unassigned fund if they're already allocated?
At the beginning of each year, we give about 2.5 to 2.6 million. It's a per student basis that cap reserve gets funded. Every mid-year, this is just our practice. Whatever money that we are not putting, we meet all our obligations for changes in enrollment, change in PPR, unanticipated expenses. Then we go ahead and we put the remainder in the cap reserve fund. That's why if you look in the budget, sometimes you will see that the actual budget for the year was like $8 million, $6 million for cap reserve, the transfer from the general fund to the cap reserve. That didn't happen at the beginning of the year. About 2.5, 2.6 happened. The rest comes at the mid-year with the dollars that would be available. But if
Okay.
we have to pay a bill prior to the mid-year, we don't have this budget anywhere. So where we would go is the unassigned fund balance, because this is not a budgeted piece.
Okay.
And our first opportunity to rectify that is in January.
All right, can you please calculate for me the percentage of 160,000 in a 30 million budget?
Well,
What
do you,
percentage of
and
that?
do you want 30 million? Because that's the unassigned fund balance. So you're
Yes.
not looking at total expenditures. Sure, I'll take 160. 160,000 divided by 30 million. And that'd be about 0.5%, about 0.5%. The other thing that
So
we,
we're talking about 0.5% out of 30 million budget for 1 year.
out of
which-
the 30 million amount that sits in the unassigned, it's not
Right.
budgeted to be spent, but
Right.
that's what we anticipate being there.
So you would still have 99.95% of the unassigned budget, correct?
Yes, if everything works out, you'd be correct
Yes, okay, thank
for
you.
that year. And I would just add that the strategy, though, may be looking forward to costs in future years to ensure that the district is poised to be able to meet those needs in the past. When I know that there's something coming up, it's something that I'd like to say, at least give some options around so that you can consider not only planning for the costs for next year, but costs if we already know what they are. We do that with different types of reserves. You may say, Becky, yeah, this year it's 160, but like you to put 500,000 in there to ensure that it can be maintained for the future.
Yeah, and even taking that out, you would still remain above 8.5%. like you like to keep it, even taking out that 0.5%. It would not drop you below your desired 8.
We could do the math on
8.5.
it and see where it ends up.
So I did the math on 125, approximately 125 per year, and you were still at 8.65. So, okay. Any other questions on cost? All right, I will just say, roughly take, just coming in thinking 250,000 over 2 years, which would, in my calculations, approximately $125,000 a year in an adopted budget of $588,635,292. That is 0.02% of our budget. That's what we're talking about. That leaves 99.98% of the adopted budget the same. So just keep that in perspective when you're thinking about the amount that we're talking about. So if there are no other questions, I think it's time for a motion. Are there any other questions?
May we be excused?
Yes, Mr. Murray and Mr. Ellis, you may be excused. Yes.
Thank you.
Yep. 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 Yep.
Okay.
Just read the script.
Okay, I make a motion to approve joining School District 49 versus Sullivan et al., number 25-CV-1463.
Second.
Roll call, please.
Vice President Cons,
Aye.
Director Wilburn,
Aye.
Director Yanez,
Nay.
Director Payne,
Aye.
President Shandy.
Aye. All right, I greatly appreciate the discussions that we've had in public. I really do. I appreciate the people who have come to talk. Miss Allen, thank you for your questions. I appreciate that. Superintendent Haberer, I appreciate your diligence in helping us overturn every stone so that we have going in wide, eyes wide open. So I appreciate that very much. This meeting is adjourned.